He ate his last meal 9 times, not once, not twice, 9. 9 times the state of Oklahoma told Richard Glossip that he would be dead by midnight. 9 times guards brought him a final dinner. 9 times he sat alone in a cell, eating what he believed was the last food he would ever taste. Then something happened that almost never happens in the American justice system. The United States Supreme Court looked at the evidence and threw out his conviction entirely. But that is not the end of the story, because Richard Glossip is not free. He is not exonerated, and the state of Oklahoma, the same state that tried to execute him 9 times, is preparing to try him again. This is the case that has lasted almost 30 years, reached the highest court in the land, and is still not over. This is the story of Richard Glossip. The best budget inn on the outskirts of Oklahoma City was not the kind of place people remembered fondly. It was a budget motel on the edge of the city, the kind with flickering corridor lights and thin walls and guests who paid by the week. Barry Van Treese owned it. Richard Glossip managed it day to day, checking people in and out, keeping the place running. On the night of January 7th, 1997, Van Treese arrived at the motel to check on the books. He had concerns. Money wasn't adding up. He and Glossip had a tense history over how the motel was being run. Sometime in the early hours of that same night, Justin Sneed crept into room 102 where Van Treese was staying. Sneed was 19 years old. He was the motel's maintenance man. He was also, according to later testimony, addicted to methamphetamine. What happened in that room is not disputed. Justin Sneed beat Barry Van Treese to death with a baseball bat. What is disputed? What has been disputed for nearly 30 years, through 2 trials, 9 execution warrants, and a ruling from the United States Supreme Court, is whether Richard Glossip told him to do it. Justin Sneed made a deal. He would plead guilty to the murder. He would testify that Richard Glossip had hired him to do it, paying him $10,000 to commit the killing. In exchange, Sneed would avoid the death penalty and receive a sentence of life in prison. Richard Glossip, who did not touch Barry Van Treese, who did not hold a baseball bat, who denied any involvement from the very first day, Richard Glossip would face death. The trial moved quickly, and the case against Richard Glossip was, by any legal standard, thin. There was no physical evidence connecting him to the murder. No DNA, no fingerprints, no weapon with his touch on it, no money trail proving the supposed $10,000 payment, no independent witnesses who heard the alleged deal being made. There was one thing, and one thing only, connecting Richard Glossip to the murder of Barry Van Treese: the word of the man who committed it. Justin Sneed took the stand in 1998 and told the jury that Richard Glossip had organized the killing, that Glossip had come to him with the plan, that Glossip had promised him money, that Glossip had told him how to do it. Sneed was the prosecution's entire case, and the jury believed him. In July 1998, Richard Glossip was convicted of murder and sentenced to death. 3 years later, the Oklahoma Court of Criminal Appeals looked at the trial and described the case against Glossip as, in their own words, extremely weak. They threw out the conviction and ordered a new trial, finding that Glossip had received constitutionally inadequate legal representation. That should have been a turning point. It wasn't. In 2004, Oklahoma tried Richard Glossip again. The star witness was the same, Justin Sneed. The evidence was essentially the same. The outcome was the same. Richard Glossip was convicted of murder for a second time and sentenced to death for a second time. What nobody in that courtroom knew, what would not come to light for nearly 2 more decades, was what had happened behind closed doors between Justin Sneed and the prosecution. Sneed had at some point before the trial disclosed to prosecutors that he was receiving psychiatric treatment, that he had been diagnosed with bipolar disorder, that he was taking lithium. This matters enormously, because at trial, when Sneed was asked whether he had ever sought mental health treatment, he said no. He lied. On the stand, under oath. about a fact that went directly to his credibility as the prosecution's only witness. And the prosecutors, according to the United States Supreme Court, knew he was lying, and they let him lie anyway. Richard Glossip went back to death row. What followed over the next 2 decades is almost without precedent in American legal history. 9 execution warrants. 9 times the state of Oklahoma set a date for Richard Glossip to die. Each time his legal team found a reason, a procedural issue, a new piece of evidence, a constitutional argument to seek a delay. Each time he came closer than the last to the end. In 2015, he came the closest of all. 3 times in that single year, Oklahoma set an execution date. 3 times Glossip sat in a holding cell and ate a final meal. On the 3rd occasion, in November 2015, his execution was halted with less than 4 hours to spare because prison officials discovered they had obtained the wrong drug. The potassium acetate they had received was not the potassium chloride specified in the execution protocol. A clerical error about which chemical would be used to kill him. That is what saved Richard Glossip's life that night. Sister Helen Prejean, the nun and death penalty activist whose work inspired the film Dead Man Walking, had taken up Glossip's cause. A bipartisan group of Oklahoma legislators began calling for a review. Advocates around the world shared his name. And through all of it, 9 execution dates, 3 last meals, almost 30 years. Richard Glossip said the same thing. He didn't do it. In 2022, a bipartisan group of 62 Oklahoma state legislators commissioned an independent investigation into the Glossip case. The law firm they hired was one of the largest in the United States. Their conclusion, after an exhaustive review, there were grave doubts about Richard Glossip's guilt. More than that, the investigation found that the state had deliberately destroyed key physical evidence before Glossip's second trial, including items from the crime scene and the motel's financial records, which might have contradicted the prosecution's motive theory. Evidence that should have been preserved was gone. Then came something even more extraordinary. Hidden in 7 boxes of previously undisclosed documents that had never been given to the defense, investigators found a note from a trial prosecutor that appeared to show an attempt to coordinate Justin Sneed's testimony in advance, to make sure his account aligned with the physical evidence, to shape what the only witness in the case would say on the stand. And there was something else. Justin Sneed, the man who killed Barry Van Treese, the man on whose word Richard Glossip had spent nearly 30 years on death row, had, on multiple occasions over the years, privately sought to recant his testimony. His own family members believed he had lied. His own daughter publicly stated that she did not believe her father's account was truthful. Justin Sneed, who beat a man to death with a baseball bat, has remained in prison, but he will one day be eligible for parole. Richard Glossip, who touched nothing and no one, had been scheduled to die. In January 2024, the United States Supreme Court agreed to hear Richard Glossip's case. The oral arguments heard in October 2024 were unusual for a reason that is almost unheard of in the American legal system. Typically, the state argues against the defendant's appeal. In this case, the Oklahoma Attorney General had already concluded that Glossip's trial had been fundamentally unfair. Both sides, the defense and the prosecution's own Attorney General, were arguing for the same thing: a new trial. The Oklahoma Court of Criminal Appeals had rejected this position on procedural grounds, essentially ruling that because the Attorney General had changed his mind, it didn't count. That procedural rules mattered more than the truth. The United States Supreme Court disagreed. On February 25, 2025, in a 5-3 decision, the Supreme Court vacated Richard Glossip's conviction and ordered a new trial. Justice Sonia Sotomayor, writing for the majority, was direct. prosecutors had knowingly allowed false testimony from their key witness and failed to correct it. The conviction could not stand. After 27 years, after 9 execution warrants, after 3 last meals, after 2 trials, 2 death sentences, and 2 trips to the highest court in the land, Richard Glossip's conviction was gone. This is where most stories would end. Conviction overturned. Man freed. Justice, however delayed, finally served. That is not what happened. Oklahoma announced it would try Richard Glossip for a 3rd time. The Attorney General, who had himself argued that Glossip's trial was unfair, announced that he still believed Glossip had some role in the killing, and that the state would pursue a murder conviction again, this time without seeking the death penalty. Glossip was transferred from death row to the Oklahoma County Detention Center, a facility described by legal observers as one of the most overcrowded and poorly maintained jails in the United States. He remained there as judge after judge assigned to his retrial recused themselves, all of them former prosecutors with ties to the same district attorney's office that had built the case against him. The machinery of the retrial stalled. In December 2025, his health began to deteriorate, a blood clot. His lawyers filed urgent motions arguing that continued incarceration posed a risk to his life. And then, on May 14th, 2026, almost exactly 29 years after Barry Van Treese was killed, an Oklahoma judge granted Richard Glossip bond. He walked out of jail into the sun, stood next to his wife Leah, and told reporters he was just really happy. 29 years, 9 last meals, 1 Supreme Court ruling, and he is still waiting for his 3rd trial. As of today, Richard Glossip is out on bail, awaiting a retrial that has not yet begun. The Attorney General has said the state will not seek the death penalty this time, but they will still try to convict him of murder, still try to send him back to prison, possibly for the rest of his life, on the basis of testimony from the man who admitted to the killing. Testimony the Supreme Court of the United States has already ruled was false and was knowingly allowed to stand. Justin Sneed remains in prison. He may one day be released on parole. Barry Van Treese is dead. His family has lived with this case for almost 3 decades, through every twist and every reversal. And Richard Glossip, a man who by any measure did not receive a fair trial, is living in something that does not quite feel like freedom. Out of prison, but not yet free. Charged but not convicted. Waiting for a 3rd jury to decide what 2 previous juries, working with false evidence, got wrong. What does justice look like in a case like this? I don't think the American justice system has answered that question yet. Richard Glossip's retrial has not yet been scheduled. His case continues. If you want to follow this case as it develops, subscribe. We will cover every update as the retrial moves forward. And if this video made you think, leave a comment below. Do you believe Richard Glossip is innocent? Do you think a 3rd trial is justice? Or a continuation of the same injustice that started in 1997? I'll read every single one.